Hi friends, in this video we are going to deal with the important judgment titled PARVATI DEVI versus the state of BIHAR, now state of JHARKHAND and others, pronounced on 17th December 2021. This judgment deals with that once the prosecution is able to establish that a woman was subjected to cruelty or harassment for or in connection with any demand for dowry soon before her death, the court shall proceed on a presumption that the persons who have subjected her to cruelty with demand for dowry have caused dowry death under section 304B of the Indian Penal Code. To know more about this case synopsis, please watch the video fully. The facts of the case would be that a case was registered by the local police against the accused for the offences under section 304, 201 and 34 of IPC. On completion of the investigation, a charge sheet was filed against all the three accused for the aforesaid offences along with section 3 and 4 of Dowry Prohibition Act. 5 days after lodging the FIR, a skeleton was recovered from the banks of river Barakar at a distance of about 1 kilometer short of village Sarmadi, which was assumed to be that of the deceased, the daughter of the informant. Charges were thereafter framed against the three accused under section 304B read with 34, 201 read with 34 of IPC. After trial, the trial court convicted the accused under section 304B and 201 read with section 34 of IPC and sentenced them to undergo rigorous imprisonment for a period of 10 years and 3 years respectively on each count, with both the sentences running concurrently. Aggrieved, the accused approached the High Court. The Jharkhand High Court upheld the trial court's judgment of conviction. Being aggrieved, the accused are before the Supreme Court. The Supreme Court has held that section 304B of IPC, read in conjunction with section 113B of the Indian Evidence Act, leaves no manner of doubt that once the prosecution has been able to demonstrate that a woman has been subjected to cruelty or harassment for or in connection with any demand for dowry soon before her death, the court shall proceed on a presumption that the persons who have subjected her to cruelty or harassment in connection with the demand for dowry have caused a dowry death within the meaning of section 304B of IPC. The said presumption is however rebutable and can be dispelled on the accused being able to demonstrate through cogent evidence that all the ingredients of section 304B of IPC have not been satisfied. In the instant case, despite the shoddy investigation conducted by the prosecution, the circumstances set out in section 304B of the IPC have been established in the light of the fact that the deceased had gone missing from her matrimonial home within a few months of her marriage and immediately after demands of dowry were made on her, and that her death had occurred under abnormal circumstances. Such a death would have to be characterized as a dowry death. The plea raised on behalf of the accused that the body recovered from the banks of Barakar river was unidentifiable is devoid of merits when PW3, the father of the deceased, testified that he could recognize the dead body as that of his daughter from a part of the face that had remained intact and from the clothes that were found on the body. As regards accused number 1, the High Court and the trial court have rightly raised a presumption against him under section 113B of the Indian Evidence Act, which prescribes that the court shall presume that a person has caused a dowry death of a woman if it is shown that soon before her death she had been subjected by such person to cruelty or harassment for or in connection with any demand for dowry. The case of the prosecution rests solely on circumstantial evidence. No eyewitness has been produced who could testify as to how the body of the deceased was found on the banks of river Barakar. There is sufficient evidence brought on record to inculpate accused number 1, the husband of the deceased. The circumstances put together unerringly point to his guilt in extinguishing the life of his wife within a few months of the marriage on her failing to satisfy the demands of dowry. The impugned judgment and order of sentence imposed on accused number 1 does not deserve interference and is maintained. As for accused number 3, the mother-in-law, from the evidence on record, only certain omnibus allegations have been made against her with respect to dowry demands. The respondent state has not been able to indicate any specific allegations nor point to any specific evidence or testimony against her. In view of the above, it is necessary to interfere with the findings of the courts below, convicting accused number 3 for the offence under sections 304B and 201, read with section 34 of IPC. She is directed to be released forthwith, if not required to be detained in any other case. Friends, to conclude, in this video we have seen that once the prosecution is able to establish that a woman was subjected to cruelty or harassment for or in connection with any demand for dowry soon before her death, the court shall proceed on a presumption that the persons who have subjected her to cruelty with demand for dowry have caused dowry death under section 304B of the Indian Penal Code as per PARVATI Devi versus the state of BIHAR, now state of JHARKHAND, and others case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.